We are all aware of what this whole thing is leading to, so no problem. Chairman, we the minority hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokolo. We believe that the acting Chief Justice wields the administrative power on this matter, and just as the injunction applications were held expeditiously, same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither parliament ally in political projects. It is a guardian of our constitution, the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee, and the country, that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any questions. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report. You have not said that. You have not said that. Listen to him. Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us, and we say that on the basis of that, we cannot be part of a process that would give right to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Yes, no, she believes in us.
Does not amount to my leader speaks at will. I mean, he speaks at will. We all know the practice in this house. Leader, you have to catch the eye of the speaker. You have to respect the chair. This attitude of suddenly punching the microphone and speaking, you are our leader, but you are a member of parliament. You are subject to the same rules as apply to all of us. So, Mr. Chair, I think you should have a word with our leader.
Thank you very much.
Your consent.
Honorable Minority Leader, be guided and candidly land safely. Yes, Honorable Ayarga.
So I raise an objection to his reference to a judicial decision and the conduct of a judge. And the rules are very clear. I really don't understand why the minority leader wants me to keep reciting the rules. Because everybody knows that the rules are clear. You can't say that about a decision of a court. You can't say that. So you have to expunge that.
Honorable Majority Leader, I have heard you. Honorable Minority Leader, be guided accordingly. And proceed.
Chairman, with respect, what we are saying is that we disagree with the said decision of the court, and it's our right to have a disagreement with the court, most respectfully. Especially so when we are of the view.
You see, Honorable Minority Leader,
Chairman,
you can disagree with all due respect with the decision of the court. And when you disagree with the decision of the court, you know what to do.
That's not a problem. But we are making a comment, Chairman. Chairman, I've held my calm throughout all of this. I gave you my word, proud to this verdict, and I've kept my word. Today in Ghana, you cannot even speak as a parliamentarian to express a view. You will be stopped by the majority leader. I am not attacking the court. I'm saying that the minority disagrees because we have the rules book, the CI 16. When you apply for extension of time, there's a time period. You can't go beyond 2 weeks. We have the provision, so we cannot disagree with the court. We cannot cite the court's own ruling and say on this we disagree. What is happening here? Because somebody has super majority? What is happening in this country?
Minority Leader,
What have we done wrong?
I will not have a problem.
I have not attacked any judge. We've not attacked the court.
By way of a question that will give an opportunity for a response. You are making a preliminary comment.
Exactly, that's exactly what it is. That's exactly what it is.
The rules.
I don't have a problem.
Make your preliminary comment as such.
Very well. Chairman, thank you. So we expect that steps be taken by the court to expeditiously hear the cases brought before it by the respected learned Justice of the Supreme Court, who until removed was the Chief Justice, Her Ladyship Gertrude Araba Isaba Tokolo. Expeditious hearing of this matter and a final determination of this matter will reassure the Ghanaian public that the rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy. A strategy to ensure that these cases languish undefended, creating space for this right competition to proceed.
Yes, Honorable Ayariga, let me hear you.
Why?
Now and then, the minority leader will say that we are politicians and we should be allowed to do politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. Impute improper motives. I repeat again, impute improper motives or impugns the integrity of a member or any other person. The Speaker may order that the member withdraws those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution, and he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives. Saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear. That any reference to the conduct of persons mentioned in Rule 7 in any amendment, question, or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed he has impugned improper motives, you should order him to have it expunged from the records. And I'm saying that he has impugned, he has imputed improper motives, and therefore he should expunge that from the records.
Yes, Honorable Minority Leader. Mr. Chair, Honorable Minority Leader, please put off your microphone. Please put off your microphone. Yes, Honorable Minority Leader, you have the floor.
He's a member.
Mr. Chairman, some of my... Yes, sure.